Okay, you're all set.
Okay, thank you. So this meeting is convened by video conference in compliance with Governor Cuomo's executive orders, which suspend certain provisions of the open meetings law to allow municipal boards to convene meetings via video conferencing without in-person attendance by the public. In addition, the public has been provided the ability to view, hear, and participate in the meeting. A transcript will be provided at a later date. There's a quorum of the board members for this meeting. The link to the live stream of the meeting has been provided to the public, and a video of this meeting will be made available on public access television, as well as a link on the town's website. Further, all submission materials and agendas are available to be viewed on the town's website. So our first matter, we'll skip around a little bit here. Our first matter will be a decision. This is the Meadowhill subdivision. This is lot number 2. This is an application for a site development plan approval, wetlands and stormwater permits, last heard on October 8th. So I think we closed the public hearing last time around, and we're now just at the stage where we have a resolution before us. Alan, I hope that you've had a chance to take a look at it and you're okay with it.
I did. I'm fine with it. It seemed very straightforward.
Okay. Anyone have any questions on the resolution as has been drawn up?
No.
I had just one question. One question that had to do with the deer fencing. Alan and Dennis, do we have a sunset on that? Do we plan to keep that deer fencing in there, in perpetuity, or is this just something that's temporary to give these plants a head start to get set up?
Well, that's a good question. I think really right now the idea is that it's going to be, I'll use the term temporary. Basically, it's the duration is long enough to get the trees to be above browse height. As for shrubs, I guess it depends upon the future homeowner and how that future homeowner feels about it. The plan is to move it away from the closest proximity to the house. So if it doesn't bother the homeowner, it may very well end up staying for a longer period of time. But otherwise, I think the intention is to eventually remove it. And hopefully we won't have to have it encompassed that way.
Right. Dennis, is there a recommendation in terms of what you would like to see, if anything, in the resolution regarding some sort of minimal time frame, sunsetting of this requirement?
Well, I could tell you from working at other sites, I mean, a year seems reasonable, and part of that is, not just from the plant's perspective, but you're able to get, an indicator as to if something's trying to get in. That's another way, because I know that Meadowhill had an issue when the fence originally tore and had to be repaired, and obviously something got in there, so something wants to get in there. So, that seems like a reasonable time frame, because then after a year, if it worked, then you can make some of the assertions that Alan is making, that okay, we achieved this level, we're at this height, do you think that we're above browse height, something to that effect, and then you have justification to sort of turn it around and say, okay, we could remove. So I would say a year is reasonable, because you want to just kind of get through the seasons.
Okay.
Especially if it's a harsh winter, et cetera.
Sure.
So we could just insert some language saying, for a minimum of a year, and then of course just leave it to the property owner in terms of what they want to do afterwards. Keep it, take it down, whatever. But again, jumpstart the plants, the vegetation here.
Is a year enough?
Mm-hmm.
Dennis seems to think so. I don't think we should impose more conditions, frankly, but I saw it open-ended. I wouldn't want the homeowner to be sanctioned later on 5 years down the road because there's this condition and it hasn't been, there's no release from it. I don't know, Dick. But Dennis seems to think a year is fine. Alan, do you have any thoughts on it?
No, that's fine. I have no problem with leaving it for a year. That's reasonable. And if the homeowner wants to extend it, that's what the homeowner will do.
Right. And you also, too, to keep it, I would think there's some benefit, too, to keep things protected at least for a year. If there's a nursery guarantee that usually has that duration, then the assertion that, you're left with just nibbles and you're trying to get a free shrub out of it, that may not work out as well,
Okay. In one of the, in fact, I think the minutes we look at tonight, Dick, you had mentioned something about the vegetative screening to the property. I think it's due north, for vehicles coming in and out. Is that part of the landscape plan? Are you satisfied with that, Dennis?
Yes, and I think there was also some existing vegetation that was serving that purpose as well. So it, I didn't want to, there's no need to overdo it, so to speak, with new.
Exactly.
If, you have mature existing to try to complement, I thought was a better approach.
Good. Okay.
Yep, that's fine.
Good. Okay. Anyone else? Any thoughts, questions?
Chairman Kirkwood, this is Jennifer. I'll just mention on page 2, there's 2 blanks for the square footages for the existing clearing and grading limit line and then the proposed area. So those are just 2 data points. I just wanted to mention those can be filled in before the resolution is finalized, before it's filed in the town clerk's office.
There's also something on page 4 that's blank too, on or about. There was a date left blank.
Yes, those dates, I believe Felicia fills those in now post-approval because it's based upon the filing of the resolution in the town clerk's office. So given current status, typically it would be filed the next day with, staffing and COVID issues. Sometimes it takes a couple days to occur.
Okay.
So I just want to make sure that's accurate.
Good. Anyone else? Any thoughts, questions, issues? If not, is there a motion to adopt the resolution?
So moved.
Second?
Second.
Okay. Eldad?
Aye.
Tom?
Yes.
Dick?
Aye.
And I'm aye, so that's 4-0. Motion's carried, and I think we're all set with this application.
Thank you very much. I very much appreciate it.
Very good. Okay, the next item is the decision on the application for Singh, 15 Heathcote Drive. This is an application for a subdivision approval, lot line amendment, merger, wetland permit, tree removal permit, stormwater permit, 15 Heathcote Drive. So again, I think we closed the public hearing during the last time we looked at this. And again, we have a proposed resolution before us. Staff has proposed.
Don't forget, it was updated.
Yes, I wanted to bring your attention to that update. Felicia had sent you yesterday, I think, a red line version of the resolution, which contains some areas that the applicant had commented on that are right for your discussion. So if you want to go through those, and any other questions or discussion items you want to take.
Hi. How are you, Sabrina?
Hi, good evening, Dr. Singh.
Hey, how are you guys? Nice to see all of you.
Yes, nice to see you too.
Let me just pull up my red line copy. Okay.
Hi, Chief. Hello, Chairman.
Okay. Some of these changes were, I think, made by Bob. All right.
Yes,
some
the applicant
technical issues.
the applicant had raised some issues and Bob and I had addressed them. Most of the ones in the document were made by Bob. I don't know if Jeri, if you want to kind of go through them for the board as Bob Kirkwood brings them up.
Sure. We've gone through everything and it was very helpful to talk with Bob and Sabrina earlier in the week and to try to go through some of these things. And I think we are pretty good with everything. I know with the red line on comment 27, we
Can you give a page number for everybody, Bob? Jeri?
I'm on 5 of 6, comment 27. It's about the septic. So and I think what we discussed at the meeting was that we will show the full build out of the septic with the full grading limit line. And we will apply for the waiver, so we don't have to build the septic reserve. We think we'll get it because there's good access right off the driveway to the backyard. And if that's the case, we'll build the alternative plan. So I think all we need to do is insert sheet 2 of 8 in the first instance and sheet 7 of 8 in the second instance, and I'll email that information to Bob. And
Copy Felicia on that, Jerry, so that we can
Okay.
cite it in the resolution as it's indicated in the red line.
and
I have a-
so
I have a typo in number 27. We're talking about the septic. I don't know which line it is because I don't have that one in front of me, but it's the word fill, and I think you want full. It's very multicolored. I can say that whole section there.
Well, no, I think it's
full.
it's full. The applicant shall demarcate and label the full extent of the onsite, meaning that the whole septic system.
Yeah, sure.
Right.
Okay, good. So someone changed it because when I read it before, the word was fill,
Okay.
not full.
Okay.
Well, just to be clear, so it's the full extent of the system, but later on, Mr. Brownell, it's the fill waiver. I just want to make sure we're not crossing.
Thank you.
Yeah,
Good for
that's how I
you.
took it.
My head was spinning when I was looking at all the colors.
So we're good with that, and I think we only had one other question, and I'm going to let Brad talk about that.
Thanks, Jerry. Good evening, everyone. It's just a clarifying on condition number 35. It was just getting some clarification exactly what that meant and what
Because that
would be-
confused me.
Yeah.
Me
Go
too.
ahead.
So my head was spinning on that one also. So
Oh, you're asking for clarification. Me
Yes.
too. I don't. To me, it seems like it's asking the applicant to do some investigation work, paperwork. I don't
Is
understand.
this something we requested?
Yeah, I don't recall it at all. That we
It was
requested this.
part of your discussion.
I thought we were going to have a discussion about that issue for the whole area.
Yeah, I think that this one's actually on us, not the applicant. If we,
Yeah, I agree.
So we should strike that.
Yes.
Yeah.
yes.
Does that solve your concern, Brad?
done.
It makes me happy.
Which is that?
It's all about that.
Which condition is that?
35.
Shall include a summary of the background information?
Yeah,
Yes.
if they proceed with any kind of an application.
Yeah, okay.
Are you okay with that, Clinton?
Yes.
Okay.
There was, I think, also, I had a question on, I think it's paragraph 21, and this deals with the construction sequence. It seems to me that we had a discussion and that at the very outset, it was agreed that whatever buffer vegetation was going to be installed between this homeowner and the adjacent homeowner, that would be done also at the very outset. So I think that should be, if people agree with my recollection, I think that should be at least part of the construction phasing plan, and that should be front-ended. My understanding was that Jeri agreed that that would be something that they would do right at the beginning, and they could do it.
Yeah, we just got to make sure we have a temporary water supply, but I'm sure we can work that out. I know Bob was, I think this originated with Bob. He wanted to make sure that we had the retaining walls up and we had the protections to the wetland buffer area up. So, we didn't have to build that later. So when we put that together, we'll make sure we include installation of those buffer plantings along the north property line.
Okay.
Okay.
How do we do that, Sabrina, to note that? Do we just add wording here as part of the condition, or is that just be something that will be noted for Bob for the phasing plan?
We are going to add it as a condition.
Okay, internally.
Internally, Felicia has kind of what you talked about, and between Bob and I, we'll get it inserted into the resolution and make sure that it's clear.
Good, super. Sounds good to me. Anyone else, anything? If not, is there a motion to adopt the resolution as amended?
Motion.
Second?
Okay.
Tom?
Yes.
Dick?
Yes.
Eldad?
Yes.
And I'm yes, so the motion carries. Resolution is approved 4-0. And I think we're all set with that one.
Terrific. Just want to thank you all for your efforts on this one. Appreciate it. I know Dr. Singh is here and he's appreciative as well. So
Thank you, everybody. Thank
Okay.
you so much, Chairman.
Thank you
Yep.
all.
Yep, good luck.
Hey, Clinton, thank you.
Good night.
Good night.
All right,
Good
good
night.
night.
Thank you.
Good night.
So we
Sabrina,
have,
You're
Uh,
welcome, Doctor.
I am going to leave also unless anybody wants anything from me.
Thank you, Clinton.
You're welcome.
vanilla ice cream on a cone.
I was thinking the same thing, but then I thought, maybe, cherry vanilla.
I would prefer it in a dish. Thank you.
Oh, there you go. See? All right. Good night,
I'm
Clinton.
going to
Thank
the
you.
store. I don't know whether I'll make it back with the ice cream.
Well, then you'll have to eat it all.
Thank you.
So
Okay, we
long.
have a request for an extension of an approval. This is on the Bucknecki Ellert, 60 Inningwood Drive. This is an application that we approve for a site development plan amendment for an accessory apartment, wetlands permit, tree removal permit, stormwater pollution prevention plan at 60 Inningwood Road. So, any problems or issues with it, Sabrina?
None.
Okay. Any concerns, thoughts, anyone? If not, do we wish to move forward and grant the extension requested by the applicant?
Yes.
No problems? Okay, is there a motion then to grant the approval sought by the applicant on this application?
So moved.
Second?
No, I'm thinking about, I'm confused on it, I have to say. I'm just trying to get myself unconfused. So this extension takes them to where? I mean, the dates on here are, what are the extension would be to October 21st, 2021, right? And
Correct.
so that would be including the building permit, right?
Yes.
Okay, then I'm ready to vote.
Okay.
So
Did
you
we have
have
a
a
second?
motion?
Do we have a second? Okay. Dick,
Yes.
Eldad,
Yes.
Tom?
Yes.
And I'm yes, so the request for the extension is granted 4-0. Bob's still not back, so we can go into the exciting minutes. So we have the minutes from September 8th before us.
I forwarded some comments, to Felicia,
Right, okay,
minor ones. I don't think they're a problem.
okay.
I do have one that's interesting. Why do we say that one of our members is absent?
Well, back then Greg was still on the board. So he was in fact absent that night.
Ah, okay, cool. Yeah, that's right. Thank you.
We're ready for your next trick question, Dick.
Well, thank you. Are we moving to the next minutes where I have one?
Any questions? Anyone on this?
No, nothing of
not,
significance.
Is there a motion to adopt the minutes of September 8, 2020?
Yes, with Dick's comments that were sent to Felicia.
Right, as amended. Very good, thank you. Do we have a motion?
So moved.
Second?
Second.
Do you do a roll call on this one too?
Yes.
Okay. Eldad?
Yes.
Dick?
Yes.
Tom?
Yes.
And I'm yes. So the minutes are adopted 4-0. And we have the minutes of the, this is our special, no. Yeah. Our meeting of October 20. Just last week. It seems like we're getting minutes almost before we finish the meetings.
That's great.
It's like these are like real time minutes.
There's still two backlogged.
Okay, you got to slow down a little bit, Felicia. This is like current history. So anyway, any questions on the minutes here?
Yeah, line 63 of the first page. Dennis?
Yep.
A question for you. It says that they're going to spray the Phragmite, or the Phragmites. What do they use? What do we use these days, or what do they use to spray it? Or is that? I know a lot of times you try and pull it up, but that's hard work.
Yeah, no, the spray is thought it was a glyphosate, glyphosate, maybe I'm saying it wrong, but anyway, it's something that you need a licensed pesticide applicator to use, and for frag, it's not uncommon to need more than one application for sure,
Yeah.
especially in this area. From what I saw, it's pretty dense.
Right. So this wouldn't have the phosphate wouldn't have any impact on water supply or anything downstream or anything like that?
That's part of the reason it's supposed to all be done in accordance with the licensed applicator, that, you know, there's certain mitigating measures that need to be followed with respect to minimizing, you know, the amount that you use. It's definitely not, you know, copter overhead aerial assault. You know, you're supposed to cut them. You're not supposed to do it on a windy day. Everything is supposed to, you know, be a direct application, and some even use a excuse me, it's a almost like a wet sponge, you know, to dap the planting. So they try to keep it localized.
Okay. And do we know that a appropriately licensed application firm is doing this? Do we get that kind of information, or should we get that kind of information?
We could request that to verify that, but that would be the requirement. I know that I did happen to meet the person who was doing it the first time I went for another reason, to actually look at trees, and just happened to meet him, and we had a discussion, but we could get that documentation, yes.
Okay. I'd be happy with that.
Do we also, when we do that, Dennis, do we also get, this is, I guess, an internal thing, really not for the planning board, but do we get internal controls and information about whatever environmental coverage that these guys may have, and other liability insurance in case something goes awry? Because to Dick's point, this is in a sensitive area, and
right,
proximate to drinking water areas.
I would have to confer with Bob and Tom how that works with respect to the sort of overall project. I don't have that answer off the top of my head.
Okay. Good.
That's a good answer. The truth is always good.
Dennis?
Yes, sir.
I've got just a question about this, which really doesn't relate to the application, but does the town have any kind of a program to treat this problem on town lands?
Interesting.
Well, it's in this case, you know, obviously for Sunshine, it's a first step to sort of remove this species, but then there's, you know, an active plan to replant with something else that, you know, gives opportunity to, you know, grow, propagate, compete. So if we were to do something like this on town lands, and just do that and no follow-up, I'm not sure it would be a long-term solution.
Right.
Because eventually this, you know, if left, you know, to its own devices, it's not a permanent kill. It's just to, you know, get rid of it while you have to then, you know, go to the next phase and put in natives and that type of operation.
Okay, thanks. Just curious.
Okay. Anyone else? Any
It's
questions?
here to stay, Mr. Curley. That's all I'm going to say as a species. It's definitely a, you know, a problem for sure.
Right. Okay. Is there a motion to adopt the minutes of October 20?
So moved.
Second.
Eldad?
Yes.
Tom?
Yes.
Dick?
Aye.
And I'm aye, so they're adopted 4-0. Shall we move now into Nikic? Is Bob still tied up, or?
He is tied up.
Okay.
He's tied up, but he did give me a for him if need be.
Okay. So I think Bob was the only one who offered some comments here. And basically, no, Dennis did. Dennis has a memo also. So Dennis, why don't you bring us up to speed on your findings and your issues?
Sure. I think it was just an accounting issue. And actually, Mr. Grau had sent an email today with an image of the check and the amount that was indicated in the memo to satisfy the balance. So I replied that, you know, when I get the paper live version, when I'm able to return to the office, I'll work that through finance and get that credited to this application.
Okay, great. Sounds good. Anything else, Dennis? Substantive on the application itself? You're satisfied at this point with the tree count and the cuts and the replacements, et cetera?
Yes.
Okay. So Sabrina, do you want to go through Bob's memo? It looks like pretty much everything's set except for one of the conditions, number 4, that he's emphasized here.
Yeah, he just wants the draft resolution to, not the draft, he wants the clearing and grading limit line declaration to be reviewed by council prior to C of O.
Okay.
And accepted by council.
Okay. Any problems with that, Mr. Grau?
No problem at all. We're actually ready to go. I believe our lawyer, who's on this email right now, on this Daniel there, has already organized a lot of that and been working with Jennifer. Is that correct, Daniel?
That's correct.
Yeah.
Great.
Yes,
Okay.
yeah, we do have a draft of the clearing and grading limit line declaration, and it's under review between the town and my office. Great.
Now, Jennifer, we have a little bit of a hiccup here. Perhaps you can bring us up to speed on and procedurally what we do at this point. Oh, I'm sorry. You know, by the way, this was a public hearing, so there should have been. You know, I get all mixed up here. There should have been a motion to open the public hearing. So I'll entertain a motion to retroactively open the public hearing.
I'll move.
A second. You got to help me out here with a retroactive motion.
Sorry, I was muted. I seconded and I seconded
Okay,
now.
perfect. Thank you. All in favor?
Aye.
Aye. Okay, we were set on that. Sorry. I got mixed up when we went back to the bottom, and we always put our public hearings at the top. So, so we are in a public hearing, but apparently it's had a little bit of a hiccup here in terms of what we see from the council. And without getting involved with long drawn out explanations, I guess, Jennifer, it's fair to say that even though we're getting very close to the end at this point, we need to get these a few of these things buttoned up. But we, based on the letter, we may be unable to move forward to close things up here.
Yeah, so just a brief summary. You'll see in Bob Cioli's memo, the last paragraph, there's reference to performance guarantee, and that's from the original subdivision. The Brandywine original subdivision, there was a performance guarantee that was posted in 2009 for all of the infrastructure improvements throughout the, for the overall subdivision. That performance guarantee was reduced in 2015. It has since lapsed. There is no performance guarantee, and there remains infrastructure improvements that need to be completed for the overall subdivision. So my office has issued a notice to all the property owners involved to let them know that this performance guarantee needs to be replaced, and we've advised that the town can't proceed with further land use approvals or decisions, including permits and COs, until the performance guarantee has been posted, and we've left it to the homeowner, the property owners, and that includes Mr. Nikic, Kingfisher, as the owner of 3 lots, and also Sterling National Bank. So our recommendation is that you shouldn't proceed to the approval stage. We can continue to process the application up to that point, but until we get the performance guarantees back in place, that the further, decisions, land use decisions should not be had by any board.
Okay.
May I
So
have
with that,
heard on that at some point?
Yeah, sure.
Is now a good time?
Not on the legal issues, that you have to work out with counsel, but sure, any update would be fine.
I don't know if it's a legal issue or not. I am the attorney. I represent him on the sale, and we were ready to close back in July. We would have closed back in July, but for this issue. And I received this letter this morning. Mr. Nikic owns 2 properties that are also next door. The life of a developer is that he has basically all of his money sunk into this project, and bonds are expensive. We're ready to close on this one. We would really appreciate if there's any way that we could get a CO on this one and condition the COs for the other 2 properties on getting the bond. I have made some phone calls. We're working on getting a bond in place, but it's going to take time and it's going to take money. And we really need to close on this one if possible prior to. So I don't know if that's something that might be an option.
so given what Mr. Pancotti has just said, Chairman Kirkwood and board members, what I would recommend is that we continue the public hearing, but perhaps what the board could do is direct staff to prepare the resolution. You can continue the public hearing to a date certain, and Dan and I can have conversations along with Nick Ward-Willis of my office, who's also involved in this issue, and try to work out a resolution here that works for the town and works for the property owners as well. But that way, if a resolution is had and we're able to move forward, at least you'll have the resolution prepared and ready to go at the date of your continued public hearing.
And I think that's probably all we can do at this point until we hear further.
Okay. Yeah, it's again, it's a financial hardship. So if there's any way you can work with us, I'll talk to Jennifer later about it, and appreciate your consideration.
Okay. Are there any comments from the public on this matter, Carrie? Anyone out there?
If you're interested in speaking, please raise your digital hand.
Mr. Nikic also owns the 2 neighboring properties, and he's not able to be here tonight, but he has no objection.
Okay.
And the other neighbor, I believe, is the sawmill. I think it's county property, and then I think there's one other home.
Right. But this is a little bit complicated because we have the other property owners involved as well. So it's, we understand the hardship for you, but we're also dealing with, I guess, who is it, Kingfish and the bank, et cetera. And I imagine this letter just came out, so you haven't really had a chance to talk with the other property owners, the other interests in this yet?
To a limited extent, I spoke to Mr. Grau, who was also working with the other property owner, coincidentally. And we are going to do something, and it's just going to take a little bit of time. And this one we were hoping to close on a few months ago. So if we could get this one closed and condition it on the other 2, that would really be helpful for my client.
Okay. There's someone here trying to speak, Carrie?
Nobody raised their hand. I just sent them a message. There is one attendee.
Okay.
And if you're having an issue, you can also type in the chat box. Okay, there's no one right now then.
Okay, any questions, comments from board members before we, at suggestion of council, adjourn the public hearing to another date? And do we want to instruct staff in the meantime to prepare the resolution so it's ready?
I think that's a great idea.
Okay.
And that would be for, if you can continue to December 1st.
Okay. Okay. So I think we need a motion then to direct staff to prepare the resolution. Is there such a motion?
So moved.
Okay, second.
Second.
Okay, Tom?
Yes.
Eldad?
Yes.
Dick?
Yes.
And I'm yes, so it's 4-0. And we will adjourn the public hearing then until, what was it, Sabrina? December what?
First.
December 1. Okay, very good. Thank you. All right, very good. We'll see you then, and good luck with the bonding and the discussions. Okay, we're about the end. We have a special meeting in connection with the form-based code and the DGIS for next Thursday, 6:30. I think it's the 12th. So what I would suggest, we had a little conversation beforehand. What I would suggest is all of us submit written comments for changes and observations that we have, and we can put that all together in connection with the memo that we received from Felicia, which addressed some of the points that we talked about last week. And then next Thursday, we'll have this material, and it seems to me that we could make some real good progress toward putting together a memorandum to the town board.
Are you submitting comments to Felicia or are you handling that, Bob?
I think amongst ourselves. So, I mean, we'll copy everyone in so everyone has it. But I think it's one of those things where, you know, these are not necessarily the thoughts that we're going to go with, but at least people get, you know, pen to paper and get the ideas out to all of us. And when I say all of us, it's not just the 4 planning board members, but I would, you know, please include Sabrina and Bob and Dennis and obviously Felicia and
please make sure to include myself too.
Yep.
Absolutely.
Sorry, can I just clarify?
Sure.
Next week, so the 12th, we had talked about having a discussion on the code itself, right?
Yes, it was. I think we had talked about
the DGIS
time for the form-based code.
The code.
But I don't think. From my perspective, I wasn't really set with what we have so far from our thoughts in Felicia's memo.
Agreed.
So I think there's still more work to go on the GGIS. That's not to say that we still have to get to the form-based code. So if we have to do another special meeting, we may have to do that. My understanding is that the town board is having another public hearing on November 10th. Is that correct?
Yeah, correct.
And may or may not close the public hearing at that time. And then they've also committed to a 30-day time frame. So I think there's still time for us to meet again and work out what we need to work out. So I think my thoughts are we may or may not get the form-based code at all on Thursday. We may just spend most of our time really working on the DGIS. I think the form-based code part of it will probably go faster.
That makes sense to me. I just wanted to make sure because I knew that initially we had talked about separating them, and I thought that we would discuss the EIS memo tonight. I'm happy to not.
We didn't put it on the agenda, and so what we will do is notice the meeting for next week for both the DGEIS and the form-based code. So if you get to it, then you can discuss it. But we have to notice appropriately, and we didn't notice it on your agenda tonight.
Got it. Are we? Last week we did not open the discussion up to public comment. Do we expect to do that next week or no?
No.
Okay.
These are, I think these are just internal meetings for us. The public comment, I mean, the town board is taking the public comment. And after all, what we're doing is really just working on what is going to be our comment on the draft GGIS.
Great, and the code itself.
Yep.
So Bob, can I ask a question here? Because I'm a little bit confused. And Jennifer and Sabrina, I'm sure you can help out on this. I understand our position as an interested agency on the DGEIS, and our comments to that I think are appropriate. That we do that and pay attention to that. What is the platform for a discussion of the form-based code itself? That's really a different subject, isn't it? I mean, it's a related subject, but it's a different matter. Is that something that we do by invitation of the town board, or is it something we're taking up independently, or is that something which is done within the context of our role as an interested agency in the DGEIS?
So the form-based code is, as you know, an appendix of the DGEIS. And currently there is a public hearing open on the form-based code itself. So there's actually 2 public hearings that are occurring concurrently right now, one on the DGEIS and one on the form-based code. If you have specific comments on the form-based code itself, now would be the time to voice those comments, because I think it will help inform the further revisions that we know are inevitable to the form-based code as we move through this process. There will, however, be further opportunities to comment on the form-based code itself after the adoption of a finding statement concluding the environmental review process. There will be another separate public hearing on the then existing form-based code.
And that will be in the context of a proposed legislation, is that correct? And that then is our opportunity within the context of the town's process, not the state process.
Yes.
But the town process.
Yes, it will have to be referred to you formally for your comment at that time as well.
So reviewing it now would be, do I have this right? You mentioned that it was an appendix to the DGEIS, and so that's our platform to review it now.
Correct.
Yep, and there's an open public hearing on the code itself now currently, yes. So both of those reasons would give you the platform for reviewing it and commenting on it now.
That's great. I just wanted to be sure we weren't sort of raining or raiding somebody else's parade without actually having a more formal avenue to be doing it.
No, I think it would be appropriate to comment on it now, and I think your comments will be helpful to the town board and the consultants as they move forward down this process.
Okay,
thank you. So to Tom's point, we're commenting on it at this point because it really is part of the draft GEIS, so it really falls under the SECRA rules at this point as an interested agency. Later on, that will be a different referral. So even though it's 2 different segments, because it's been rolled into the draft GEIS and it's really an appendix to that document, it is therefore governed by the SECRA rules.
Mm-hmm. Presumably, when the final form-based code comes up as part of a legislative process, I'm guessing that it won't be chapter and verse and in every detail the same as the draft form-based code, which is before us now. We would assume that there might be some changes.
Right. I think that it's safe to assume that there will be changes to the form-based code.
Okay, great. Thank you.
Okay. Anyone else?
I have one small comment for Felicia. Felicia, the thing that we talked about with my comments that I sent to you, when you go in tomorrow to the office, would you please make sure that everybody else gets a copy?
Absolutely.
Good. Okay, great.
Bob?
Yes, sir.
I mean, I don't want to be delaying things in our work with the town board, but if we're going to be going over again our comments to the EIS, right? Mm-hmm. Next time, the relationship between these 2 documents can be a little bit tricky, and could be relatively easy. And I got a little bit uncomfortable the last time we talked about the EIS. We seem to every once in a while sort of wander into the criticism of talking about the code itself rather than the environmental impact statement. And would it be okay or appropriate to say that we really ought to break these 2 discussions up into 2 separate meetings so that we're able to keep things clear, or is that making things delaying things by too much?
Well, I think that's what we're planning to do. We would only touch base on the form-based code if we have time and have wrapped up our discussion on the EIS. But I think we're sticking with our original plan to keep those discussions separate and apart. Now, if we do it at minute 50 in our meeting and then we just segment from there and we go on to the form-based code, that's fine. If we don't get to it, we'll schedule a separate meeting for it. But I think the recommendation that we heard from Nick, I think made a lot of sense, and that was to keep these as much as possible distinct, and for discussion purposes and for purposes of our memorandum.
Well, great. I'll rely on, I think Nick and both Nick and Jennifer were going to join us next time for this.
It'll be one or the other of us.
Okay.
There's
I
a
think
couple
Nick
of
said
meetings.
he was going to do it to keep consistency.
We
Okay.
we will trust one or the other of you to keep these things straight as we talk about them and not sort of veer out of our lane.
Good luck.
Okay.
Great. Anything else? If not, is there a motion to close the meeting?
So move.
Second?
Second.
All in favor?
All right.
Aye.
Okay. Good night, all. Thanks so much.